Section 3 we
Yes.
completed.
Yeah. Yeah. The provision relating to 32, that is the 8 circumstances which are enumerated therein are exception to the general rule that the hearsay evidence, that is, hearsay admission is not really admissible. That is what we said. But these are the exception to the general rule that the hearsay evidence with regard to 8 circumstances become admissible. That is, with regard to the death of the person, the circumstances leading to his death, under 30, 32, 31. Then, when the relates to cause of his death, and we were discussing against the interest of the maker. So 33 Kanda, you learn the person who a self-serving statement he makes, they are not admissible. Self-harming statements are admission. Self-harming statements. Suppose if an entry is made, I owe you a lakh of rupee, it is self-harming. If I say that if I had to collect 1 lakh rupee from you in future or my grandfather, that is not an admission under the provisions of section 21. Similarly, it cannot be brought. So for the purpose of 32(3), against the interest of the maker, mean the person who is making this statement must have been dead or not traceable. When the statement against the pecuniary proprietary interest making, when it's true, it would expose him to a criminal prosecution or to a suit for damages. So these are the statements of a dead person. They are statement of a dead person which are sought to be proved uh, by by these evidence which is on record. It may be by through witnesses, it might be by their own writing. The person has made in his books of account certain statements which are against his interests. They become admissible in the court of law. So this is a 32(3). Now under 32(4), or gives opinion as to public right, custom, matters of general interest. Mean the opinion given by a dead person or an opinion given by elderly person in the community who is no more alive. As regard the public right or custom, matters of general interest. So you know that the evidence with regards to public right and customs are admissible under section 1(3) of the Indian Evidence Act. You learned it here. Fact relevant when right custom is questioned here. So when certain easementary rights are claimed by parties or certain general right is claimed, see the opinion of the Gram Panchayat president, which were in record that that particular road belongs to a general public, or that particular church or a temple belongs to a so and so institution where public visit here, and almost everybody has a right. And the opinion given by the elders, the opinion given by the mukhya of the village with regard to the right of custom, matters of general, can also be proved here, because the right to customs are proved under the provisions of section 13 and 32(4). Then you may also see such rights are proved under the provisions of section opinion is given under section 48. See, opinion as to the existence of a right of custom when relevant. Then the opinion as to usages under 49 are 48 and 49. This is to be read along with it here. So a person who cannot be brought before the court of law, he opines here. There may be a dispute under the provisions of section 92 of the CPC. You file a public interest litigation is filed, or a representative capacity suit is filed, or in public, or in with respect to any public institution as to who should use it, who should not use it, whether it was a temple like the Ram Mandir, whether it was a temple, whether it was a masjid. whether what was it here. So the opinion was sought by the Supreme Court of various people. So the all people who gave opinion, the inscription, the books which were brought, they were all dead. They were under 400, 400 to 600-year old documents are brought on record. So that is the finest example. The court, the opinion with regard to public right, custom, and general matter can be accepted by the court, taking recourse to the provisions of 32(4). Okay. So these are all hearsay evidence which becomes admissible because under the scheme of the Evidence Act, there is no room for derivative evidence or hearsay evidence except in certain circumstances mentioned. For example, res geste statements we gave you. Now 32 is the finest example. All these people are not before the court. These people are either dead or could not come before the court, could not be found before the court of law, and statements are given due weightage and proved before the court of law, both in civil and criminal proceeding. Okay. Then item number 5, um, relating to existence of relationship. When statements relate to existence of any relationship by blood, marriage, adoption between persons, or relationship by blood, marriage, or adoption by person making the statement special means of knowledge, and when the statement was made before the question dispute was arise. So several people, see, when a person dies and he files a suit for declaration that I am the adopted son of Mr. So and so, that person is dead and gone. He is not there. And how do you prove the adoption of a dead person? Or there must be adoption deed. Adoption deed in India, many times in many communities, there is no adoption deed. People are illiterate, isn't it? Then you gather evidence that the deceased person treated you as his own son. For example, when he was alive, when I was a small child of 4 years, 5 years, 3 years, he took me to a school, and in the school application form, he has shown his name as a father, and I am his son. So that evidence can be shown before the court of law. This is the declaration of a dead man to show that the relationship between us. So I was the adopted son, in fact, otherwise he would not have made this entry. Similarly, you may examine um, some village officer where the entries were made in his books showing relationship, or some ration card where the persons are dead and gone, the entry is showing in public document as father and son. These are all to prove that here the dead person had treated you, and to prove consanguinity, blood relationship, for if a person seeking a declaration, I was related to him, that I am entitled to right title interest under the provisions of Hindu Succession Act, Indian Succession Act, or in Mohammedan law, whatever may be. So this will show the relationship between the parties when a person is not alive, when the defendant is resisting the claim that no such adoption took place and such person was not there. You are a fictitious person, fraudulent person, and you have been set up only to grab the property. ये सब चीजें आते हैं इसके अंदर. So you seek the opinion. You can bring evidence indirectly. What could not be attained directly can be attained indirectly. So the law helps you, the Indian Evidence Act. So you can bring the declaration, the signatures of the person or the persons who are alive during the lifetime, what the deceased had told them about you, about your relationship. So finest example is a school record. So you may be a man of 50, 55 now. Huh? You are fighting for the property of the deceased, and the brother and sister of the deceased are claiming right. Under the Hindu Succession Act, you being the son, you will have a preferential train. The brothers and sisters will be second degree claimants. So you are a first degree claimant. So if you are eliminated, they will get a chance. They will say that you are nobody. So you have a right to lead evidence in this regard to show that the relationship. Okay, the best finest example I show it to you, the school record where you were treated, municipal record, or the elders in the village or where a custom usage was established, adoption to take place. So that evidence is hearsay evidence of elderly persons. With regard to the deposition of a dead man can be proved here. So you are proving the statement of a dead person. You are proving the statement of a person who is not in existence and who cannot be brought before the court of law. So derivative evidence is sought to be established here in this matter. Next, or is made in will or deed relating to family affairs. When the statement relate to existence of relationship, blood or adoption between the person deceased and is made in any will, deed relating to the affairs of the family to which such deceased person belong to, or family pedigree and the tombstone of a family, portrait or other things, which such statements are usually made, and where such statements are made before the question dispute was raised. So you are also entitled to lead evidence from the recitals made in the will. So your grandfather made a will stating the nature of his family, that his forefathers came from a particular region. They acquired so and so property. They bequeathed him the property. And your grandfather has so many children. Then he has created a private family trust. The property has been given to a trust. So the pedigree of the entire family background is given, which can be ascertained from the document. What the elders in the family have narrated, given description about the consanguinity, about the relationship, connectivity with each other in the matter, that can be proved. Sometimes dead people are not there. In which year your forefather died, you may not know the exact date. You do not have a diary. You go to the in England, because many there are tombstones. In that there is a inscription in the stone. So and so is so and so died on so and so date. And the dates are given there, and he is the son of Mr. So and so there. That can be brought and proved before the court of law to prove the existence of family affair, to prove the relationship between the parties, plaintiff or defendant, in that matter. So you are the by virtue of the evidence which is collected indirectly, you are proving the statement of a dead person to sustain your claim in the court of law. Either both plaintiff or defendant, who is a plaintiff may be asserting, defendant may be refuting. So you can lead evidence in that regard to prove the relationship between the parties from the statement of a dead person. Then number 7, or in document relating to transaction mentioned in section 13, clause A, when the statements contained in any deed, will or other document which relate to any transaction in mentioned in section 13A1. 13A1 deals with your customs and usages, which I just told you. You can have a look at again section 13. Section 13 of the Evidence Act, facts relevant when right or custom is in question. When the question is as to existence of a right or custom, following facts are relevant. Number 1, any transaction by which any right or custom was created, claim modified, recognized, asserted, denied, which was inconsistent with the existence. Like under the Hama Act, Hindu Adoption and Maintenance Act, a child above the age of 15 cannot be adopted. But you may lead evidence to show that you, in a particular community, a custom exists even till the age of 20, 21, adoption is recognized. So you will be permitted to lead that evidence to prove a custom both under section 13A, under section 48 also. And if the person is dead and gone, from a dead person entries, from a diaries, that can be proved under 32(7), a person who cannot be brought. So easementary rights can be proved, customs can be proved, and usages in the community can be proved for establishing the right title interest in the matter. Okay. Then 8, or is made by several persons. and expresses feeling relevant to matters in question when the statements were made by number of person and expressing feeling or impression their part relevant to matters in question. Now this illustration, this is very important here. Now let us see that here. We'll understand this from the illustration. The illustrations in number one. The question is whether A was murdered by B. The question is whether A was murdered by B or A dies of injuries received in transaction in the course of which she was ravished. The question is she was ravished by B. The question is whether A was killed. B under circumstances the suit would lie against B and A's widow. Then the statements made by A as to the cause of his death or death, referring respectively to the murder, rape, or actionable wrong under consideration or relevant fact. So this is for the purpose of proving under section 32, subclause 1, proving the cause of death. Okay. Illustration, like B check kare. The question is as to the date of birth. What is the date of birth? An entry in the diary of a deceased surgeon regularly kept in the course of a business stating that on a given date he attended A's mother and delivered her a baby is the relevant fact. Now this in the course of the business 32(2) में आ जाएगा ये. So a surgeon in the hospital where the mother was admitted and delivered a baby and he did not know his date of birth, he can ascertain from the surgeon's diary. Because the surgeon has maintained the diary in the usual course of his business. Like an advocate will maintain a diary that which client came and who made the will deposition in the usual course of business, it is relevant. So the surgeon's ka is coming under section 32(2) के लिए example. Number 3. The question is whether A was in Calcutta on a given day. The statement in the diary of a deceased solicitor regularly kept in the course of a business that on a given day the solicitor attended A at a place mentioned in Calcutta for the purpose of conferring him specified business is a relevant fact. So this is again to prove the course of a business, a professional discharging his duty maintained diary. So in the course of in the A which who is being prosecuted for an offense in Delhi may take up the plea. I was in Calcutta, I was not there. So he will prove it from the I had gone to meet my solicitor who attended my case that the entries are relevant to prove that transaction. Okay. Yes, next. D. The question is whether a ship sailed from Bombay Harbor on a given date. A letter written by the deceased member of a merchant firm by which she chartered on their correspondence in London to whom the cargo was consigned, stating the ship sailed on a given date from Bombay Harbor is a relevant fact. Here, this again, this is a fact 32(2) के अंदर आ जाएगा. Known an agreement receipt is again a course of a business. Is in the course of it when it consists of trying a memorandum made or kept in the ordinary course of business. So the captain keeps this diary in the regular course of his business. Then the question is whether rent was paid to A for certain land. A letter from A's deceased agent to A saying that he has received rent on A's account, is held A's order is a relevant fact. Now this will show that against the interest of the maker. So the landlord may deny that the rent has not been paid, but the maker is making a statement that rent has been received. So this will come not only useful to you under 32(3) and also under section 21, which we read earlier. Under section 21, a statement, an admission made by a person which is against himself is binding, not otherwise. See, proof of admission against a person making them or by their behalf. And admissions are relevant and may be proved as against the person. So the statement is made which is against him. It is a statement. No, it is not a self-serving statement. It's a self what you call it self incriminating भी नहीं बोलूंगा मैं. It is admission of a liability of a person, so that statement is binding. So the question that the rent notice which he has given can be proved that it is illegally given. In fact, there is an admission and report. Then F. The question is whether A and B were legally married. The statement of a deceased clergyman that he married them under such circumstances that the celebration would be a crime is relevant. So the clergyman is making a statement in that regard. He is giving an opinion. No, he is an opinion. He is a man with regard to some custom or some matter. He is in interest. So whether the marriage took place or not, a pandit or a clergyman giving a statement before the court as regard the relationship. You are proving the relationship between the husband and wife, whether they are legally married or not. So for proving the relationship, the opinion of a clergyman is relevant in that regard, though it is a hearsay evidence. Then G, the question is whether a person who cannot be found wrote a letter on certain day. The fact that letter written by him is dated on the day is relevant. So the question is whether a person who could not be found wrote a letter on a certain day. The fact that letter written by him is dated on the day is relevant. So to ascertain the fact that whether he was found or not in the matter, and his whereabouts are where, whether he is in Mumbai or Calcutta, he sent a letter from Mumbai to Calcutta. It's a fact that he is alive. Is relevant with regard to prove this fact. Then H. The question is, what was the cause of the wreck of the ship? A protest made by the captain whose attendance cannot be procured is a relevant fact. So the ship was destroyed in a stormy night here, and the captain protested and sent some emails and messages. So whatever he has sent messages, that is these are he is making against his own interest, a maker. So they are all acceptable in evidence as a hearsay evidence. Then the question is whether a given road is a public way. The statement by a deceased headman of the village that the road was a public way is irrelevant. So a dead person's statement with regard to whether it is a public way or not, that definition will be, I think, 32(4 में आएगा. देखे ना, giving opinion as to public right or a custom. So this will be covering 32(4). Please note that you can mention. Then J में check कर लीजिए. J में the question is कौन है? हाँ लेके आना. Okay, दे दो, रखो दे दो. The question is whether 9 बजे का लाओ. The question is what was the price of a gain on a certain day in a particular matter. The question is, what was the price of grain on a certain day in a particular market? The statement of the price made by the deceased Bania in the ordinary course of his business is a relevant fact. So again, we are back to 32(2). In the ordinary course of nature, the Bania, the shopkeeper who is a specialist in selling items, he knows the rate. The rate fixed by him is relevant because what exactly was the rate of the grain which was in dispute, whether the contract, whether the grain was delivered in time, what is the price agreed upon, whether the contract was a time was the essence of a contract. Okay, that the statement of a deceased Bania who handled the situation and who mentioned the rate is relevant because the statement is acceptable. He is a person who deals in such matters. Then, K, the question is whether A, who is dead, was the father of B. The statement, the statement by A that B was his son is a relevant fact. So that will show the relationship between the parties. So relationship existence 32(5) के अंदर आ जाएगा है. Please note that this is to show relationship. The statements made by him to somebody else, his friend, or in a or maybe in an invitation card or wedding card, he declared himself, he is my son, he is my so and so. That statement can be proved in the court of law. Then a letter, the question is, what was the date of birth of A? A letter received A's deceased father to a friend announcing the birth of A on a given day is a relevant date. So here with regard to the date of birth of a particular person, what was his date of birth? That date of birth may be in dispute in a particular proceeding. So a letter received formally from his father or some relative will prove that in that card. That will show the relationship between the parties in that regard. M. The question is whether and when A and B were married. An entry in a memorandum book by C on a deceased father of B of his daughter's marriage on a given date is a relevant fact. So that will show the again family affair and relationship between the parties. It can be brought within the purview of both 5 and 6 to bring the evidence on record, that is hearsay evidence of third parties and dead person. Then end here. A's use B for libel expressed in a painted caricature exposed in a shop window. A's use B for libel, that is for defamation, expressed in a painted caricature exposed in a shop. The question is as to the similarity of the caricature and its libelous character. The remarks of the crowd of a spectator and those points may be proved. So the remarks of the crowd are proved like res geste under section 6. You know that under section 6 में पढ़े आपने illustration के अंदर the cries the A is accused of the murder of B by beating him. Whatever said or done by A and B or the bystanders at the beating shortly thereafter form the part of the transaction or relevant. So similarly, in clause N, when a person dies for proving whether the particular particular fact, libelous act, or what was the reaction of the public after seeing? For example, M.F. Hussain, the painter who died, he painted some of the goddess nude. Many of the political people, religious people were outrageous. They abused him and he ran away from the country. So, suppose in a suit is filed for claiming damages for whatever reason, for sentimental reason, or he filing a suit for a recovery of money for damages, or public filing a defamation suit, and all these cries and the public collected and the remark are evidence which can be used because the persons who um, put up such uh, put up such remarks and the crowds uh, relating to libelous character are admissible under the provisions of section 32 last one. That is, that will come under section 32(8), mean or by several person are expressing feeling relevant to matter. So it is a nature of a res geste statement falling under section 6 also. You know. So illustration N with regard to the caricature and libelous expression falling within the ambit of section 32(8), which says that statement made by dead person or persons who cannot be brought and their feelings relevant to matter is questioned. How people were hurt, how people in a crowd express their disgust with the painting of goddess which has been shown in a nude character. So when a suit is filed by either party for claiming damages or injunction restraining him from committing the offense of libel, these are relevant which can be proved. So that will take care of the evidence that is a hearsay evidence, the general exception to hearsay evidence, because section 60 mandated to you that the evidence must be direct. Isn't it? हमने पढ़ा था हमने section 60 के अंदर. Section mean the person who saw he must come and depose. The person who perceived he must come and see depose. A person who has felt feeling, that is a direct evidence, which is the best evidence. Then the second type of evidence with the provisions of section 62 and 64 tells you primary evidence. The document must come on record before the court. 60 ke andar the law said that the person who has seen must come. But 32 is a departure. The people who saw and who heard are no more. They are dead and gone. So similarly, a statement made by a person under 161, 162 CRPC, they are not brought, they are dead. When they are dead person, what that means the dead person statements cannot be proved? Certainly not. It is not like a dead person is dead in a criminal trial and the trial is extinguished. In civil cases, the cause of action accrues under Order 22, Rule 4. You are brought on record. See, under the Evidence Act, even a person is dead and gone, he cannot be brought. His evidence, if any, which has been left out, can be adduced, can be irrelevant, and it can be proved some through the persons who is a living person or from the record diaries maintained by the dead person. So the Evidence Act makes admissible what could not be brought directly can be brought indirectly. Please note that here. So if you do not have direct evidence, you can have primary evidence. If there is no primary evidence, you can have secondary evidence under 63 and 65. If there is no secondary evidence, you can have presumptive evidence. You can have circumstantial evidence. Circumstances, you may not have any witnesses. So the law permits you, the circumstantial evidence can be given. So, sir, even 32 permits you to draw inferences here. The 32, the how you draw inferences is given. We read out the provisions of 114 of the Evidence Act. Pura pade humne all how the court draws natural inferences. Then we read out the provisions of section 79 onwards till 90 tak, how the court shall presume and may presume. Then we read out the provisions of section 41, 112, 113 to prove what is shall presume, what is conclusive proof, reading section 4, may presume, shall presume, conclusive proof. So this particular section 32 adds a dimension, embellishment to the Evidence Act, placing on record that not to worry, if evidence is not available in any forum, the court is going to allow the evidence of a dead man who could not come before the court. Persons who are living in remote villages cannot come before the court. But what they have said about a particular incident, about a matter which is relevant to the matter in issue, their evidence can be brought before the court. So a man is dead in a murder trial. Mr. A is dead and gone. Like in Pakal and Narayan Swami's case, the daughter and son-in-law write a letter to the man. We want to pay you back money. Come to my house. He goes there. He saw the letter. He saw the letter and he read out to his wife. The wife knew about the letter. It was in her possession. When that man goes to collect the money from the daughter-in-law, from the son-in-law, and very cruel person, along with his wife, who is his daughter, they bring a trunk, put his body and chop it up and send. The body was found in Puri. Very unfortunate, railway compartment ke andar. No, there were no eyewitnesses. But the wife tells the police during investigation, yes, just before my husband disappeared, I received this. One day, my husband received this letter from his own son-in-law. Please come and collect your money, 30,000 rupees. Oh, padhiye aap judgment, bahut acha judgment. Pakala Narayan Swami's case. On the basis of that letter, that is a dead man's letter, that giving the cause of his death, circumstances leading to the death, and they were arrested and they were convicted. So, dead man's evidence can be proved by somebody else. So that is how the beauty of section 32. It is an exception to the general rule that hearsay evidence has no role to play. So hearsay evidence becomes admissible by virtue of section 32 and some parts of section 6 of the Evidence Act, which you will have to bear in mind. Anybody wants to ask me a question, ask before I turn to section 33. Okay, we have another 10 minutes, I think. We'll today cover also section 33 of the Evidence Act, which I had discussed with you while discussing the Salman Khan case. That is the section 33. कोई question है कुमार? नहीं ना अभी? 33 देख लेंगे. Today 33, 34 cover कर लेता हूँ. We'll stop it, then thereafter देख लेंगे. 33 आ जाइए. Hopefully section 32 is clear to you. Now, relevancy of certain evidence. Kindly see section 33. Relevancy of certain evidence for proving in subsequent proceedings the truth of facts therein stated. Some evidence may be containing, there may be A proceeding and B proceeding. There may be parallel proceeding. You may have filed a suit in a civil suit for recovery of money on check bouncing cases. The famous 138 proceeding under the negotiable. So check bouncing cases come under the provisions of Order 37, Rule 1 and 2 CPC, check bouncing cases. Your statements in that maybe you have shown before the court how the transaction came into play, how you know the defendant, and how the liability arises. डालें उसके साथ में आपने parallel proceeding भी शुरू कर दिए under 138 of the Negotiable Instrument Act, which is a criminal offense. You may have made certain, statements which are contrary to each other in the proceeding. When that is so, if that is so, when suppose if the consent decree in a civil proceedings are disposed of by a consent decree, wherein the defendant agreed to pay you amount, but he defaulted. But आपने consent decree में किया था admission. If the payment is fully made, you will withdraw the criminal prosecution. Criminal prosecution withdraw करने का सवाल ही नहीं रहेगा अभी. So the criminal prosecution started. So the statements made by him in the civil proceeding can be used to contradict him in that matter here, for example. Now let us see that here. Evidence given by a witness in a judicial proceeding. Underline the word judicial. Judicial proceedings are either before the High Court, Supreme Court, civil courts, civil judge, senior divisions, in all these courts which record evidence. In CRPC, session judges, judicial magistrate, first class, second class, city like Bombay, metropolitan magistrate, and this High Court and Supreme Court. So judicial proceeding take place here. Section 2R CRPC defined. Evidence given by a witness in a judicial proceeding or before any person authorized by law to take it, any person authorized by law to take it, Sometimes the courts are appointing court commissioner, authorizing them to take evidence. So you are authorized. So the court commissioners who are advocates taking evidence, they are authorized, isn't it? But arbitrators are not authorized because they're excluded. Is relevant for the purpose of proving in a subsequent judicial proceeding or in a later stage of the same judicial proceeding the truth of the fact which it is state when the witness is dead, cannot be found, or is incapable of giving evidence, or kept out of the way by adverse party, or is present, cannot be found without any amount of delay, expenses which under the circumstances in a case considers unreasonable. Now, यहाँ तक मैं पढ़ के सुनाता हूँ, I'll give you. The common examples in this matter is that parallel proceeding I gave you. Like under the Companies Act, a director of a company is given accommodation by the company. Car is being given. समझे ना? अगर company has given him, I mean, he is given by virtue of his exigencies of his employment. Now company से इसको termination कर दिया गया. और termination करने के बाद the company tells him to vacate the premises. Now, as an act of retaliation, वो क्या करेगा? He goes to the civil court, maybe the court of small causes court in Bombay. He files a declaration that I have become a tenant. Then the company will file 630 proceeding before a magistrate is holding company's property. Huh? So company before the magistrate 630 proceeding mein he company files it for taking possession of the property and he make different statement. So when those statements, in case suppose the gentleman is dead, his heirs under the in the court of small causes court proceeding come on record, claim tenancy. Tenancy is a transmittable rights, you know that. Heirs and legal representative can claim it. So whatever evidence he has given in the court of small causes court can be utilized for the purpose of proceedings in 630 before a magistrate. If there are any contradiction, you can use them. Provided he is not available, provided he is dead and all as such. Provided these statements can use, number one, that proceeding between the same parties are legal representatives. Company and the director or director's children. Unke hai. Number two, that the adverse party in the first proceeding had the right to oppose cross-examination. So in the court of small causes court, when a suit was filed by him for a declaration that I became a tenant of the company, I am not liable to be evicted, termination is illegal. समझे ना आप? Then वहां पे he must have produced the resolution of a company or a resolution of the company and how the company is whether the owner or a tenant, the subtenant, what was his capacity. So वहां के statements in the cross examination he may have admitted yes company itself is a tenant, then how you can claim the right. So that statement you can use it in the before the learned magistrate in a trial under section 630 proceeding, criminal proceeding, where is withholding the company property, which is an offense. That can be used provided he had undergone cross-examination before the civil court where the matter was contested and he was not alive. His children may take a contradictory stand. So whatever statements made by him can be utilized by you to contradict the children in the second state. Like in the Salman Khan's case, the session judge, learned session judge, made a mistake of relying upon the statement of the Havaldar, which was recorded by the police by the magistrate under section 200 verification stage for taking cognizance. Now, at the stage of the cognizance, when evidence is recorded, that it is without subject to, it is without any right to the accused to cross-examine because the accused is not called upon at the time. So those statements could not be used by the prosecution to link that this is what was admitted by the Havaldar, who stated in the first information report that Mr. Salman Khan had drunk 9 packs of whiskey, whatever maybe, and he was in an intoxicated frame of mind. He lost balance, he killed. So that statement, because he had not undergone cross examination, it was a recorded statement at the interlocutory stage of taking cognizance, so you cannot use them. Otherwise, if the trial has taken place, if he has a, there was examination, cross examination, re examination, and the previous statements of a person in A trial can be used in B trial for the purposes of contradiction, for the purposes of impeaching the credibility of a witness under section 145 and 153 of the Evidence Act, which I pointed. So 33 statements can be used. Then the criminal trial or inquiry shall be deemed to be proceeding between the prosecutor and accused within the meaning of the section. So a criminal trial and a civil trial taking place in the matter where there are contradictory statements, you can utilize it. That is the scope of section 33 of the person. You cannot say that though the finding given by a civil court is not binding upon a criminal court, and similarly the finding of a criminal court is not binding on civil court. Please, you learn that they are different, they reach a different conclusion. Just because a man is convicted by a criminal court doesn't mean that he should succeed in civil case. And merely because the small causes court has given declaration of tenancy right, he should go to jail. It's an entirely a different setup of proving cases each other. They are not. But the statements made, if they are relevant, by a dead person, a person who cannot become, if his former statements in a judicial proceedings are affecting, you can pay. And he took up a stand that he was a tenant in the earlier proceeding. And before the magistrate, he said he was a licensee. So both are contradictory. They are mutually destructive statements. They are not a convincing statement. So this man is taking inconsistent stand from time to time. You cannot be taking inconsistent stand. You cannot what you approbate and reprobate under the law. So that for that purpose, section 33 has been couched. Then 34 check kar lijiye aap. Entries in a books of account, including those maintained in an electronic form, when relevant. So entries are maintained by your Mehtaji, your accountant, your rent collector in the regular course of a business. So they become entries in the books of account, including those maintained regularly kept in the course of a business, are relevant whenever they refer to matter to which the court has to inquire, but statement shall not be alone sufficient to charge any person with liability. So section 34 requires corroboration. Now, what is a corroboration? You have to remember section 157 of the Evidence Act. What 56? Question tending to corroborate the evidence of a fact. That means examine another witness to prove that a transaction hua hai. Otherwise, the court is not bound to accept these statements of entries shown by the plaintiff or defendant in that regard. You may maintain regularly. I have been receiving salary regularly from my master. I have been receiving the rent. Your Mehtaji will maintain the rent collector. So normally those entries are, but you can take up, the other side can take up the plea. These are fabricated ones. So when you take up the plea that I have been collecting rent from all the tenant, you should at least examine one of the tenant. There may be bogus entries of a landlord with a view to claim income tax exemption. He is preparing bogus entries of a tenant. So to substantiate that your entries are correct, your Mehtaji is your accountant, you examine couple of tenants. Yes, I am a sitting tenant in the chawl in the building of Mr. So and so. I have been regularly paying the rent. Along with me, there are several tenants. Description of the building, yes, he gives. Then the Mehtaji ka account book entries are substantiated. Otherwise, they themselves cannot prove the liability. You may file a suit in the court of law when there is a dispute. When there is a dispute between the parties as to who is the landlord, isn't it? What is the nature of the suit you are required to file? Interpleader suit. You know, after CK, CPC के अंदर Section 88 and Order 35. Even an interpleader suit के अंदर a man dies, original landlord, and 10 claimants are coming on record to claim a rent. And you don't know whom to pay. You file a interpleader suit that the court be pleased to give a declaration as to who is the rent. There are 10 methajis of 10 people saying कि you give me rent. So these statements which are recorded can be proved provided they are substantiated. Now 7:55. You have a lecture now, Kumar? Another lecture hai kya?
Sir, we have one, but after some time. We can take another 5 to 10 minutes.
Okay. ये 34 हो गया, अभी 35 ले लेंगे हम लोग. ये बुक्स ऑफ अकाउंट में नॉर्मली होता है कमर्शियल ट्रांजैक्शंस के अंदर सेक्शन 34 इज यूज. देन 33 is normally used in parallel proceeding, where people file a civil suit and criminal suit against the same. Because under the scheme of our legal system, you have a right to file a suit for a recovery of your property and breach of trust and criminal prosecution for cheating, misappropriation. आपको तो मालूम है. Section 35. Relevancy of entry in public record or an electronic record made in performance of a duty. An entry in a public or other official book, register, recorded, or electronic record stating a fact in issue or a relevant fact and made by a public servant in discharge of his official duty or by any other person in performance of a duty specially enjoined by law of the country in which such book is registered, record, or electronic record is kept a relevant book. So, यहाँ पे election, यहाँ पे देखिए passport officers are responsible officers, public officers. They maintain the diary of your entire history of your family. And entries are made, passport is given to you. When a passport is lost and you have a copy and you produce it, or a original passport is proved, an entry is made, the entries can be proved. So the entries are issued, the entries are made by public servant. They have become. Similarly, a ration card is issued by the municipal corporation, Greater Bombay. The entry is made showing that you are in possession of this area. This is the address. Of course, it may not prove the right title interest, at least show your resident. You are a person who is sought to be dispossessed, who have been dispossessed. A suit is filed by you under Section 6, where title is not required under Specific Relief Act. You can show that here. I have a ration card. I have an Aadhaar card. I have a passport. So all these entries which are made by public servant are relevant document. You need not examine them as such. They become relevant, admissible. Electricity record authorities, why would they make false entries? Unless you take up the plea that the entry has been made wrongly, incorrectly, get rectified. Similarly, a first information is recorded by a police officer under the provisions of Section 154. He is a public officer. He is recording. I mean, the existence of a FIR is not disputed. The contents may be right or wrong. You can cross-examine. But the fact that the police officer has entered the FIR on a particular day, given day, it's a public document. So, under the provisions of, similarly, the information technology officers giving a certificate under 65A and B of the Act, they maintain the book. This particular message has been transmitted from A phone. So, all entries made by public servant in the passport or in the ration card, in your Aadhaar card, even the bank entries made by the banking officer, though they come under the Bankers Evidence Act, they are all public documents. So they are public officers, they are public documents. For a public document, public servant, you have to also remember Section 74 of the Evidence Act. Just open it here. 74 Collegium. See, what is a public document? The following are public documents forming the record of the fact, namely sovereignty of the authority, official bodies, tribunal, huh? Of the public officers, legislature, judicial, executive, or any part of Indian Commonwealth, or a foreign country, or a public record kept by the state private document. Even a public document in any state of a private document. Private document, your ration card is a private document kept in public record, isn't it? Uh, then certified copies of the document, public record. So these are all public documents within the meaning of law. A judgment of the Supreme Court of India and a High Court certified copy is a public document. You are not going to summon the Chief Justice of India to testify whether you issued it or not. Is normally accepted. It's a relevant document. 35 can their public duty. They are discharging their official duties. An election commission of India is giving you the election commission certificate, whatever maybe you're entitled to vote. It's a public document. So that means you can dispense with the requirement of examining them, provided you produce the original and certified copy. Okay, that is how.
Sir, kindly explain Section 74, Subsection 2, public records kept in any state of private documents. What does it mean?
74(2 ना? एक मिनट.
Yes, sir.
Yeah, open कर लीजिए. Yeah. Yeah, 74. एक मिनट, let me open this. Public records kept in any state of private document. So I gave you an example. Your family ration card is a private document. It's a private document prepared by public authorities.
Okay, sir. Got it.
It's a public document. It's a public record, and it cannot be normally challenged unless fraud is played. Somebody has misrepresented your name. वो अलग बात हो गया. That is the provisions of Section 74(2). Yeah. I'll give you some more examples if you want. 74(2). Then electoral roll is a public document, not necessary to.
Yes, sir. I understood.
Yeah.
I was confused with the term of state. Like, what does it mean here?
Yeah, 35 हो गया अभी. 36 पे आ जाइए. Relevancy of statement in maps, charts, and plans. So, statement of fact in issue of a relevant fact made in published maps, chart generally offered for public sale, or maps plan under the authority of the central government, state government, as matter usually representing the stand in such map, chart, plans, or other themselves are relevant. So, under the Maharashtra Regional Town Planning Act or any town planning act, in the country, every city, every big cities has got town planning schemes. Town planning scheme, village planning scheme, municipal corporation में division करेंगे. उसके अंदर they prepare the plans and charts. The state government invites objection. Now, under the Representation of People's Act and rules, there's a bifurcation of the territories is made for the purpose of where population increasing. So and so extra zones are created. So the plans are prepared. Public objection is invited. So and so place is being recognized. So a plan chart prepared by the government, public officers, they are all, the statements contained therein are admissible as if they are statements of a public servant. They cannot be questioned generally in this matter. Google's का map हो रहा है with regard to the world. it is authenticated by the recognized by the all countries, isn't it? For showing the location map. Um, and particular state has been bifurcated, showing the plants area geologically. Statements have been made in the world map में, India के map में, which part of state is state or reorganization act के अंदर, the territory of Maharashtra is so many thousands of square yards, and the territory of Tamil Nadu so and so square yard. So when disputes go to the Supreme Court under Article 131 with regard to territorial of the area of these states, these are relevant. Such matters do not come to general civil courts when two states are fighting territorial disputes. They come under Article 131. The Supreme Court has original jurisdiction. Like the state of Maharashtra and state of Karnataka fighting over Belgaum. Then Kerala is challenging certain legislative orders which are passed by the government. And any state boundaries के बारे में dispute चल रहे हैं, Kaveri water के बारे में, these are all certain disputes. You will see, open the Supreme Court website and find out what are the matters which are admitted by the Supreme Court directly under Article 131. That is the ordinary original civil jurisdiction of the Supreme Court of India. So ये territorial disputes रहेंगे उसके अंदर. Now recently the government of Maharashtra published Maharashtra Regional Town Planning Act के अंदर amend किया गया. उसके अंदर बहुत सारे areas को add कर दिए गए. अभी certain अभी CRZ zone, you know that here the area has been extended. Construction can be allowed so and so area. The plans have been drawn. All these plans are now become admissible. They become public documents. They can be straight away be admitted in the court of law. But a private document, private plans prepared by your architect, are required to be proved by examining your architect. But not the plans and charts and prepared by the government, state government, central government, municipalities. They are not required. They are dispensed with. They are presumed, the court shall presume that they are correct. Because हमने पढ़ा था ना उसके अंदर presumption के अंदर वो पढ़ चुके हैं हमने. Unless you challenge it very vehemently, अलग बात है. ये relevancy के ऊपर है. ये relevancy, how the is relevant, and the provisions of section 79 onwards, admissibility. Presumption arises, all this very good. The presumption about the map chart is section 87 chakra. Presumption as to books, maps, and charts. That's a presumption. The court may presume, or court shall presume. How the presumption arises. Whereas the यहाँ पे relevancy है, वो admissibility है. Evidence Act speaks of both relevancy of a document, admissibility and proof of a document. So here this chapter is dealing with the relevancy of plans. Okay, then come to 37. Relevancy of statement as to fact of public facts of public nature contained in certain acts or notification. When the court has to form an opinion as to the existence of any fact of a public nature, and statement of it is made in recital contained in any parliament, any act of the parliament, United Kingdom, or any central or provincial act, or this state notification by crown representative appearing in the official gazette in the proper paper, London, government of so and so, opposes the majesty, is relevant. So the statements which are of public nature pertaining to the government of India, official gazette, London, Her Majesty, which is under the earlier provisions of the Government of India Act, they have been admissible. So they are public authorities. All these statements are made applicable here, and the court may presume and shall presume that they are correctly done. 38, देखिए relevancy of statement as to.
Sir, may I ask on this section, Why does the act created in Parliament of UK is still relevant to the India? Doesn't that question our sovereignty? Like
Uh,
it's 70 years after we have got our republic dominion. Why do we still care about those acts?
Parliamentarians do not have time to amend the act or delete the provision. You have to tell them. Please take it up seriously. Law Commission को लिखिए आप. They have, of course, they should have deleted it. This several times the Evidence Act has been amended. They have written it because the under the scheme of the Constitution of India, the judgments which were rendered pre-constitutional judgment by the Privy Council are relevant. आप समझे ना आप? Are relevant. You cannot say that they have got the moment the Supreme Court has come into picture, you give it up. No. Under the Constitution of India, you have a special section which clearly tells you that the laws passed by the earlier Parliament, British Parliament, are to be adhered to. So it should have been, technically speaking, amended to. They have not been amended.
After listening to you, I think that it is somehow a passage given to previous acts and judgments to be still complied with.
Yeah, because our parliament still recognizes that the protection is given and judgment recorded earlier. All these are relevant and they have persuasive value and they cannot be given by. There is a specific article in the constitution. Try to lay your hand, I will lay and tell you. They have mentioned federal court and all, how they are relevant, Anglo-Indian court, special 364. Special provision as to major ports and ordinarium. Effect of failure definition of this concept 365, 366 के अंदर दिया गया है देखो. Federal court, English existing courts, articles, Indian state, ruler, even princely states. It's a comprehensive piece of document, the interpretation clauses. So long as our parliament has not taken care of made a law, makes a right, and we'll continue this. Whatever has been mentioned in the Evidence Act will not be totally deleted unless the parliament makes a law to that effect, unless the constitution itself is changed. There is no time for the parliamentarian to change the constitution. Yeah, we'll discuss. I will give the exact provision in the Constitution of India. What is the time now?
Sir, it's 8:13. I think we can complete section 38 so that we can start from 39 in next lecture.
Okay, 37 हो गया, 38 ले लो. Relevancy of statement as to any law contained in books when the court has to form an opinion as to law of any country. Statement of such law contained in books purported to be printed or published under the authority of the government of the country and to contain any such law, and reports of the ruling of the court such country contained in the books purported to be report of the ruling is relevant. Now, for the purpose of section 38, now English ruling, American rulings, now Arbitration Act, UNCITRAL laws, United Nations Commission on International Trade laws, they are emanating from straight away the Geneva Convention, New York Convention. They are all international convention. So India is a signatory to all these international convention. So the one of the article in section article I will tell you right now 255 के बाद says that we must adhere to the international convention. Are you aware of the article? Inconsistency 254 requirement of previous sanction.
It's 253.
Article 253, yeah. Legislation for giving effect to international agreement. So under 253 के हिसाब से all these international conventions we are to respect here. So the Geneva Convention, New York Convention, Untitled laws, for example, and the IPR laws, the Uruguay Convention, ये सब जो बुक्स पब्लिश हुए हैं वहां से, इंग्लैंड से, अमेरिका से, लंदन से, so they cannot be challenged. They are treaties. They are under the authority of the government of that country. Okay. तो यहाँ से भी इंडिया में भी जो कॉन्स्टिट्यूशन ऑफ इंडिया, the books municipal corporation, Greater Bombay, the municipal corporation of various authorities, the standing orders, the parliament ke resolution. So they are all relevant documents for the purpose of a dispute concerning it. They need not be questioned. The court will take them on record, provided they are relevant. These are all relevancy. It speaks of relevancy. So these documents under the provisions of 37, 38 become relevant when there are matters relating to geographical indication, international territories, isn't it? Or your disputes which are going to the Supreme Court from one state to another under Article 131 of the Constitution. They don't generally come to civil court. Now, when you open the Constitution of India, Article 131, the Supreme Court of India has got original jurisdiction. 131 रखो लीजिए, ये 131 के अंदर प्रूव कर सकते हैं आप. Article 131. Yeah. The original jurisdiction of the Supreme Court subject to the provisions of the Constitution between the central government and the state, between the state government and various states, between two or more three states. So ये jurisdiction में all this reference can be made, relevancy of this 36, 37, 38, read with the State Reorganization Act and Article 121 of the Constitution, which speaks of how India is a Article 1, territory of India. India, that the Bharat shall be a union of state, territories shall specify territories they compose. Then Article 2, admission, establishment of new state. 2A, Sikkim. So when constitutional matters of importance come into play, of course, they are not relevant to you for fighting cases in civil and criminal cases. Okay, आज के लिए stop कर देंगे अभी 38
Sure,
तक,
sir.
39 से
Yes,
लेंगे.
sir.
अभी नेक्स्ट ईयर कभी लेना है बोलो.
We can continue, sir. आप अगर फ्री हो
Tomorrow
तो.
only Friday I will not take. Tomorrow I will take. Okay. Tomorrow is
Sure,
क्या?
sir. Same time, 7 to 8.
Same time, 7 to 8 because I finished
All
my.
right, sir. I think Nikhil has some question. We can take that.
हाँ बोलिए नितिन.
So one clarification, if you the Kumar article, the article which Kumar was talking on, is it Article 374, provision as to judges of federal court and proceeding pending in the federal court or before His Majesty in Council?
Which article बताओ?
So 374 article of Constitution.
Yeah, let me open this. Provision as to judges of the federal court and proceeding pending in the federal court, Majesty, yes. So by virtue of this article, all the judgments which have been given by the federal court and the Privy Council are protected, you know. Yes.
And sir, one question I had in my mind with regard to parallel proceedings. Sir, suppose there is a departmental inquiry going on against a person, and there is a separate criminal trial as well going on correspondingly. So whether is it that the statement made by a person before departmental inquiry, DPC or any other authority, whether such statements are admissible or irrelevant before the court of law in the criminal trial, or for that matter before civil court, if any civil liability has also arisen.
Section 33 speaks of statements made before judicial proceeding. But statements in an inquiry proceedings are before an inquiry officer is not a judicial officer. Is a tribunal. They are not binding.
Okay, sir.
Unless unless he is a unless he has been designated as a judge of a civil or criminal court, which is not so. Normally, inquiry officers are labor officers, some tribunal, some advocate. Tribunal themselves are not a judicial proceeding; they are quasi-judicial proceeding. So they are outside the purview of Evidence Act. So these statements which are made by a person before the inquiry officer may not be binding in civil court. Please note. I gave you an example which are binding
Understood.
is a parallel proceeding. Like in the civil court, you filed a suit for declaration of tenancy rights or ownership right of the premises. Proceedings are filed before a magistrate under 630 of the Old Companies Act. That there you can. Or proceedings finding of cheating, misappropriation under 420 and 406, 409 against a agent, and recovery of money under the Contract Act under section 74, 75. So those proceedings, because they are before a civil court, which is a judicial authority, and before a magistrate, who is a judicial authority. So far as your inquiry proceedings are concerned, I'm afraid they are not binding. Because inquiry officers are not courts.